The question is brutally simple. Can the government ban the most popular rifle in America and still pretend the Second Amendment means anything? That's the issue staring the U.S. Supreme Court in the face as Grant versus Rovella challenges Connecticut's sweeping ban on so-called assault weapons, including the AR-15. This isn't theory. It's about millions of ordinary gun owners who could be turned into felons for owning a rifle that's been in lawful, common use for decades. In this video, I'm going to break down how Connecticut's law works, why groups like the Connecticut Citizens Defense League (CCDL) and the Second Amendment Foundation (SAF) have pushed this case to the High Court, and what happens if the justices bless or strike down this kind of ban. Your rifles, your rights, and the legal future of modern semi-automatic arms are all on the line this term, setting the stage what Connecticut did and why it matters when people hear about Connecticut's assault weapons ban. They often picture a narrow law aimed at exotic, military-only hardware. The reality is very different. After the 2012 Sandy Hook Elementary School tragedy, Connecticut lawmakers responded in 2013 with a sweeping package of gun restrictions that went far beyond the federal ban that expired in 2004. The state didn't just copy Washington, it expanded the definition of prohibited assault weapons and locked that definition into its general statutes, most notably Conan, General, Stat, $53, 202A, and related provisions. Under that framework, Connecticut bans more than 70 specific models by name and then layers on a one-feature test that captures any semi-automatic rifle or pistol with a detachable magazine, plus certain cosmetic or ergonomic features. A pistol grip, a telescoping stock, or a flash suppressor can be enough to transform a perfectly ordinary semi-automatic firearm into a prohibited assault weapon. Possession without the right paperwork is a felony, with penalties that can include prison time and a permanent bar on gun ownership. Connecticut is not alone. Roughly 10 states and the District of Columbia now enforce similar assault weapon bans, almost all of them enacted after high-profile mass shootings. What sets Connecticut apart, and why this case matters so much, is that its law sits in the Second Circuit, a federal appeals court that has now reaffirmed the ban even after Bruen, calling these rifles unusually dangerous and historically regulable. That decision is the springboard for Grant versus Rovella. Meet the case, Grant versus Rovella, and the question before the court. Into that legal landscape steps Grant v. Rovella, a direct, frontal challenge to Connecticut's regime. The plaintiffs are not abstract organizations on a fundraising mailer. They are real people and real groups living under this law every day. On one side, you have individual gun owners such as Eddie Grant and Jennifer Hamilton, along with the Connecticut Citizens Defense League, CCDL, a grassroots in-state advocacy group. On the other, you have the Second Amendment Foundation SAF, a national litigation powerhouse that has spent decades fighting test case battles over the right to keep and bear arms. Their target is Connecticut's 1993 assault weapons statute, as expanded in 2013, enforced by state officials including Public Safety Commissioner James Rovella. The lawsuit argues that by banning AR-15 pattern rifles and a broad class of semi-automatic firearms that are mechanically indistinguishable from other lawful guns, the state has crossed the constitutional line drawn by District of Columbia v. Heller and sharpened in NY Sarpa v. Bruen. Procedurally, the case lost in the district court and then ran into the same brick wall at the Second Circuit, which leaned on the unusually dangerous label to uphold the ban and brushed aside evidence that these rifles are owned by millions of peaceful Americans. In November 2025, SAF and its partners filed a petition for certiorari asking the U.S. and Supreme Court to take the case. They present the justices with a single, unambiguous question. Do the Second and 14th Amendments protect the right to possess commonly used semi-automatic rifles, including the AR-15 for lawful purposes, AR-15S in real-life common use versus media myths? To understand why Grant v. Rovella matters, you have to get past the headlines and look at what AR-15 style rifles really represent in American life. Industry data from the National Shooting Sports Foundation (NSSF) estimate that more than 24 million modern sporting rifles, a category dominated by AR-15 and similar platforms, have entered circulation since 1990. Other analyses, including reporting that relies on the same NSSF figures, place the number of AR-15 pattern rifles alone at roughly 20 million in civilian hands by 2022. That is not a niche product. That is the standard modern rifle in American gun safes. Owners are not buying these rifles as political props. Survey work tied to NSSF's research shows that AR-style owners typically have several such rifles and use them for a mix of home defense, recreational shooting, competition, and hunting. In training classes across the country, the AR-15 has become the default platform for citizens who want to learn how to run a rifle safely and effectively, including law-abiding homeowners preparing for worst-case scenarios, ranchers protecting property, and volunteers participating in disaster response networks. The criminal misuse picture looks very different from the rhetoric that dominates cable news. FBI uniform crime reports consistently show that, in a typical year, all rifles combined account for only a small fraction of homicides, on the order of 2 to 4%, far below handguns and even below knives and other cutting instruments. Those tables also show more people killed with personal weapons, such as hands and feet, than with rifles. When Connecticut labels the AR-15 unusually dangerous, it is not relying on national homicide data. It is responding to emotional pressure from horrific but statistically rare events and turning that emotion into a permanent felony ban. And that disconnect matters. When courts evaluate whether a weapon is in common use for lawful purposes, they are supposed to look at how Americans actually live, not at the worst 15 seconds caught on a news camera. In reality, AR-15s are the rifles people trust to defend their families, develop marksmanship skills, and anchor their emergency plans. Treating that platform as exotic or fringe is simply detached from everyday experience. The legal battlefield. Heller, Bruen, and the dangerous and unusual trap. Once you see how common these rifles are, the constitutional framework comes into focus. In District of Columbia v. Heller. 2008. The Supreme Court held that the Second Amendment protects an individual right to keep arms for self-defense and made two crucial points. First, the amendment covers weapons in common use by law-abiding citizens. Second, the historical category of weapons that may be banned involves arms that are both dangerous and unusual in the sense of being rare, terrorizing, and outside ordinary civilian use. 2 years later, in McDonald v. Chicago, the court confirmed that this right applies against state and local governments through the 14th Amendment, closing the door on arguments that states like Connecticut can simply opt out of the Bill of Rights. And in 2022, NYS RPA v. Bruen replaced interest balancing tests with a clear directive. Modern gun regulations must be consistent with the nation's historical tradition of firearm regulation. Judges are not free to invent new tiers of scrutiny when they dislike the outcome that the text and history point toward. In practice, however, many lower courts have struggled or refused to follow that roadmap. Some have treated dangerous and unusual as a magic phrase that allows them to uphold bans on weapons that are, by any honest measure, firmly in common civilian use. Others have quietly smuggled public safety balancing back into the analysis under the label of historical analogs, leaning heavily on 20th century statutes that look nothing like founding-era practice. The Second Circuit's treatment of Connecticut's law fits that pattern. In upholding the state's assault weapons ban in August 2025, the court accepted that the regulated firearms are unusually dangerous, emphasized their use in mass shootings, and concluded that historical restrictions on certain categories of weapons provided sufficient support under Bruen. It gave far less weight to the sheer number of AR-15s in circulation or to their everyday defensive use. and it suggested that because handguns and other firearms remain available, Connecticut has not meaningfully burdened the right of self-defense. That reasoning is exactly what Grant v. Rovella asks the Supreme Court to correct. At the heart of the petition is a simple logical point with enormous consequences. A weapon cannot be both in common use and unusual at the same time. When a platform like the AR-15 has been sold by the millions for lawful purposes, defense, sport, hunting, and training, it falls squarely within the zone that Heller described as protected. Calling that same platform unusual because criminals sometimes abuse it does not change the underlying facts. It just relabels a disfavored right. Why this petition is so dangerous for gun control states. What makes Grant v. Rovella so threatening to gun control advocates is not just the subject matter, but the way the case is framed. This is what lawyers call a clean vehicle. The petition presents a single, sustained, sharply defined question about semi-automatic rifles in common use. It does not wander into ammo taxes, carry permits, or side issues that might give the court an excuse to dodge the merits. If the justices take this case, they will be stepping directly into the AR-15 debate and will have to say, one way or another, whether states may ban that platform outright. The factual record is similarly focused. The plaintiffs and their supporters have supplied detailed evidence about how many AR-15-style rifles are in circulation, how Americans actually use them, and how rarely rifles figure in homicide statistics compared with handguns and knives. They also highlight the state's own legislative history, which ties the ban to high-profile tragedies and political pressure more than to any systematic analysis of violent crime patterns. That contrast between hard data and emotional symbolism is central to the petition's strategy. If the Supreme Court rules that Connecticut's ban violates the Second Amendment, the implications will not stop at the state line. Nearly every other jurisdiction with a comparable assault weapons law has copied the same basic template list a series of models. Add a features test, and call the result unusually dangerous. A clear decision rejecting that approach would put those statutes in immediate jeopardy and force lower courts to bring their doctrine back in line with Heller and Bruen. What's at stake for ordinary Americans? It is easy to treat a Supreme Court petition as something that belongs only to lawyers and judges in Washington. D.C. In reality, the outcome of Grant v. Rovella will shape the options available to millions of ordinary Americans who will never see the inside of a courtroom. If the court blesses Connecticut's model, legislators in every anti-gun state will have a green light to copy and extend it, turning the rifle that many citizens rely on for home defense into contraband with the stroke of a pen. For individual families, that translates into more than theory. It means being told that the one platform they shoot best, trust most, and have invested time and money training with is now a felony to possess. It means being forced onto substitute firearms that legislatures, not gun owners, have decided are good enough for self-defense. And it means watching a constitutional right shrink to whatever politicians in a handful of states find acceptable at any given moment. On the other hand, if the Supreme Court takes this case and applies Heller and Bruen faithfully, it has an opportunity to make one principle unmistakably clear. Arms that are commonly owned and lawfully used by the American people cannot be erased by redefining them as assault weapons. That clarity would not end political fights over guns, but it would put a firm constitutional floor under the rights of peaceable citizens from Connecticut to California. However, the justices rule. Grant v. Rovella will expose where the U.S. Supreme Court really stands with a written Second Amendment that protects arms in common use, or with a political class that believes it can criminalize the very rifles millions of citizens rely on for lawful defense. This is not just about Connecticut. It is about whether your children and grandchildren inherit a right or a permission slip. If you care about that line, stay informed. Support serious litigation from groups like CCDL and SAF, and talk to your neighbors using facts, not fear. Our rights survive only when ordinary Americans insist on living as citizens, not subjects.